You want the case to go away, right?
Yeah.
Between you and that case is the plea, right?
Yeah.
I mean, I need you to understand that you're appealing, the thing you're appealing, the thing you want, that send it up, this appeal, this isn't a fair plea, this wasn't a good plea, this plea was under duress, doesn't make the charges go away. That's step two.
I understand what you're saying. You're not telling me again. I'm willing to.
You're going into jail. I just want you to understand that if you
I've
succeed,
been there before, man.
I just need you to say it, my friend. I'm not trying to be complicated. I just need you to understand.
I don't want to go to jail.
I don't want you to go to jail.
There's another way to do it. I feel like there's definitely
what do you think?
In the rules of the Tennessee appellate procedure that there's a way to, like, under when there's blatant violations, like I know there's ways to take away the plea. The plea is where we're at. The plea was never valid to begin.
Okay.
Because she was under a recusal that she never even bothered to answer.
So, but let's agree that the plea is invalid. Let's just start there, and I'm not debating that with you. Let's just agree.
Go from there.
Take that.
And I should have never.
Then, if the plea is invalid, not binding, not legitimate, set aside, whatever you want, the case still exists, right? Right. Because just if they sat there with a gun to your head and said, take this plea, we would all agree that's under duress, that's not fair. And that plea wouldn't ever be valid or legal or binding or whatever.
Yeah, especially when
but
tell me a lot of stuff.
Once that plea goes away, the case itself still exists. Okay? So now we've erased the plea, you still have a case.
Yeah. I'm obviously not a flight risk. I'm not. She look,
Didn't
the cognizance maybe.
And we could absolutely fight for a bond on that. But you can't fight a bond motion on a closed case. This is what I'm trying to tell you. The motions you want to fight, there are two different things. The charge itself.
So if you were in my position, what would you do? And you didn't exactly have 1,000 or how much it was to bail out, but you knew you were just railroaded in such a way that it would be a multi-million-dollar lawsuit. And you can easily prove it by the record.
I'm not. So here's the problem I have as a lawyer. I represent a lot of people. I represent guilty people. I've represented innocent people. I've represented people who deserved it. I've represented people who didn't deserve it. I've represented people who did something horrible, but I think they were in the right. I've represented people who didn't do anything at all and ended up in jail for years. I have done this. I've done 6,000 and some odd cases. I have sat there and watched people go to jail who I genuinely believed were innocent because there was a greater risk. And they made the decision, and we understood it. It was all. This is why I'm being very clear, because I always want to be very clear.
You are a Christian.
So I'm not you. I'm not in that position.
It might be I think 214. We're starting to try.
I don't have a way to prevent you. If we do anything to try to fix this, I don't have a way to prevent you from going back into custody, at least until we can address that. All right.
So I could even for whoever.
However long. I mean,
go in today.
There wouldn't be any ruling on this today. There would be nothing like that today. There would have to be, because again, after our last conversation, I was not under the impression you wanted me to do something that would put you back.
I really wasn't.
Okay. So I did not do anything that would have caused that. I didn't, because that was our communication.
I actually had the false assumption that you had gotten a look at my motions and decided to take my case because it was valid. And then I was like, wait a minute, he doesn't even know.
Oh, no. What happened is I handle complicated law. I am a person who is a go-to for the court for complicated things. And this is complicated. And I've never once said I'm not happy to fight it. But I don't have to know this specifically, because here's the thing. I've fought and won these before, and I've fought and lost them. I fought everything. And the reality is my job is to represent you and what you want, to the extent that I'm your attorney and what you want is a legal and valid thing. Now, because I left on the impression that you did not want it, I did not do it.
I still don't want it. I actually have got it in my head that, you had seen it and thought that we could fight it. But if it involves, I was
very clear last time, and I'm being very clear now what the risk is for doing this.
The risk of going back into custody. I don't see why would they need to put me back in custody?
It's not a matter of need or want.
Yeah.
At this moment, it is the exact. It's not vindictiveness. It's not intentional. It's not anything other than the process. Pretend you are anyone at all in the whole world. Mm-hmm. You're charged with theft. You go into custody. You plead. You get out of custody. The plea you're in custody not because of vindictiveness. You're in custody because of bond statutes and because of things like that.
Yeah,
It's not.
it'd be illegal.
And so, yeah, I would agree with you. I hate bond statutes. I think they're
Anybody
very
can
broken.
Just say, "Hey, he stole something."
You have no idea
how easy it is.
I literally took a case to trial 8 months ago where a guy sat in jail 3.5 years for a jury to tell him he wasn't guilty. Now,
That ain't worth it. It ain't worth it for me to fight this.
Well,
I've
here's
got a decent enough deal.
Here's the thing you need to understand, though. I don't want to be in this position again. I want to do what you want, but I don't want to leave here thinking that you don't want this to go forward because of the risk. And then a month later find out that you do.
No, I've thought about this long and hard. I had a year in jail to think about it.
Well,
But it was such a railroading, and they wouldn't look at any of my evidence. I had to take it. I had no choice to take the deal.
Well, and I'm not telling you that it was valid. I'm not telling you that it was fair. I'm not even telling you not to pursue this.
I mean, I could be looking at a good lawsuit, but yeah, it's a fight.
Well, and
I'm not about the money. I think the system is flawed when it comes to like indigent defendants are just automatically not given a voice. And even if you stand up and represent yourself, you're not given a chance.
well, and here's the other thing that you've got is the law is hyper-technical. It is. It's one of the unfair platforms about this that we say people can represent themselves, but I don't see how on earth a person could represent themselves in this system on anything complicated. Because there's this whole technical process, there's this whole technical procedure, and if you don't follow it, so like
I have the law library on tablets now. That's why
Sure.
I chose to do
And
it.
the thing that's interesting about this is I all the time will have a client send me some amazing case that feels directly on point but then it turns out it's out of Oklahoma. It's not binding on our court. Or they'll send me something from the Sixth Circuit, and the Sixth Circuit will have some law that's directly on point, but it's like actually the federal courts apply due process in a different way than Tennessee courts apply due process.
In the Supreme Court or something.
And just the fact that the Sixth Circuit doesn't binding on Tennessee, even though the Sixth Circuit is the Tennessee's federal circuit, because federal is different than state, and state laws are different than federal, and we're being prosecuted under state laws, not under federal laws.
And so I'm sorry.
No, you're good. It's
saying.
the degree of complication connected.
Here's the thing that really irks me. Judge Dalton blatantly violates Tennessee Supreme Court Rule 10b. No matter what, when somebody files a recusal motion, you have to answer that before you can proceed in that case. She ignored every attempt I made to give her evidence that the DA provided me. I have a 911 call that proves beyond any doubt that the guy lied on the stand. They didn't even mention that I got sent to the hospital by the police and was beat up by them. They didn't mention that at all in the police reports. I was charged with aggravated burglary without a warrant for that crime, without any probable cause determination for that crime. Had a felony indictment for aggravated burglary when wasn't even
this is
a
one
charge.
of those things I'm trying to this is one of those technical things that's complicated, but what you have is there are warrants you can get picked up on, or you can do a grand jury indictment. Now, a warrant is sworn out by a local magistrate, but you don't have to have a warrant for the grand jury. And so they can go to the grand jury. I have cases get dismissed in general sessions where the warrant gets thrown out. What is the warrant for?
He's on the warrant list today.
Do you? I understand it's complicated, but do you know what they are? I'm not. Give me.
Can I call my wife?
That would end up being up to these gentlemen here.
I've been complying with probation.
My friend, I'm trying extortion, retaliation, fast action. My friend, I'm looking at the same document you are right now.
Oh, Miss.
I don't know the answers yet. I will find them out as quickly as I
All I did
can.
was recusal motion.
This next court date, our court.
All right. I don't. Well, you have a warrant. This is not. This means that.
I have to call my wife.
That's
This is
I can't do anything to
insanity.
stop
I'm
this.
actually don't want to fight it. I was going to go with what you said. I don't know what they're doing now.
This is not going to
See
be
how
connected to what we're
corrupt
doing at
this
this moment. I'm not.
So this is not a violation of probation or something? This is just something Blackburn's, this is something Dalton's doing.
I don't know.
Because
You're
I had to
asking.
recuse.
I'm not.
I don't know anything more than you know, which is the paperwork I just saw. I'm not in the same great position you are.
Go ahead and put your phone